Welcome back to Freedom, Facts, and Firearms. My name is Novak, and today we'll be looking at the history of castle doctrine and concealed carry. So some of you may be wondering what castle doctrine is. Castle doctrine is the right to be secure in one's home and to defend oneself and home with lethal force if necessary. Castle doctrine arose from two English cases that affirm the right of home defense. The first case, being nameless, reads in part, "If one is in his house, and hears that such a one will come to his house to beat him, he may assemble folk of his friends and neighbors to help him, and aid in the safeguard of his person. But if one were threatened that if he should come to such a market, or into such a place, he should there be beaten, in that case he could not assemble persons to help him go there in personal safety, for he need not go there. And he may have a remedy be surety of the peace, but a man's house is his castle and defense, and where he has peculiar right to stay." So this basically states that while you are in your home, you have the right to defend yourself and even gather neighbors and friends to aid in your defense. But when you are in a public location, you cannot form a group for protection. The second case is Smain's case from 1604. The court decision is summarized: that the house of every one is to him as his castle and fortress, as well for the defense against injury and violence as for his repose. And although the life of a man is a thing precious and favored in law, so that although a man kills another in his defense, or kills one per infortune, without any intent, yet it is felony, and in such case he shall forfeit his goods and chattels, for the great regard which the law has to a man's life. But if thieves come to a man's house to rob him, or murder, and the owner of his servants kill any of the thieves in defense of himself and his house, it is not felony, and he shall lose nothing, and therewith agree. Every one may assemble his friends and neighbors to defend his house against violence, but he cannot assemble them to go with him to the market, or elsewhere for his safeguard against violence, and the reason of all this is, because to every one his house is his surest refuge. And if you thought I was going to try and pronounce that Latin, you're wrong. This court ruling basically reaffirmed the prior and said that taking a life by accident or without intent is a felony, but to take a life in defense of oneself or home is not, and no punishment shall be given. This case would go on to be the basis for the Fourth Amendment of the United States and create the process for how and when a sheriff could enter a home, requiring he must first signify the cause of his coming and request the doors to be opened, or he may make entry by force to arrest or conduct action upon the king's process. Because the courts identified one's house as his surest refuge, it prohibited the government from just willfully entering one's home without reason or legal process. Another case that influenced the Fourth Amendment and protected one's home from the government was inspired by the 1761 Act of the British Parliament authorizing the British Army to conduct warrantless searches in the American colonies to crack down on widespread smuggling to avoid customs tax. This led to a case before the Superior Court of Massachusetts on February 24, 1761, by James Otis, which read, "Now, one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This writ, if it should be declared legal, would totally annihilate this privilege. Custom house officers may enter our houses when they please, and we are commanded to permit their entry. Their menial servants may enter, may break locks, bars, and everything in their way, and whether they break through malice or revenge, no man, no court can inquire. Bare suspicion without oath is sufficient." So castle doctrine has played two major roles in America. By creating one's home as a safe haven, it has restricted the government and its agents from being able to enter it without a legal warrant. It has also established that one does have the right to use lethal force for the defense of themselves and their home. Unfortunately, today many states and local jurisdictions try to minimize or outright erase these rights by requiring people to retreat or claiming self-defense can only be claimed when the amount of force used to attack someone is equal to the amount of force used to defend from the attack. An example of that is if an unarmed man breaks through your door and starts beating you with his hands and you shoot him, you cannot claim self-defense because your attacker was not armed and therefore not using lethal force, whereas you responded with lethal force. You would be guilty of some type of homicide in this instance. If the same event occurred, but the attacker had a knife, then you would be justified in shooting him, as a knife is a lethal weapon and falls under lethal force. So your act of shooting the attacker would be equal to his attack and you could claim self-defense. If you'd like to learn more on self-defense law, I highly recommend checking out Andrew Branca's book, The Law of Self-Defense, or visiting his website and social media channels. So I had planned to combine Castle Doctrine and concealed carry into one episode, but there is so much to cover on concealed carry that the episode wound up being over 20 minutes. So I'm going to split these topics up. Next week we'll get into concealed carry history and law. Thanks for watching, and be sure to share the video so we can stay informed and educate others. See you next time.